Swayam Prabha. Digital India. Educated India.
I am Dr. Surendra Mehra, Assistant Professor, Law Department, Banaras Hindu University, Varanasi. So, this is my first lecture in the series of Civil Procedure Code. So, the first lecture is on suit by indigent person, order 33 of CPC. So, this order is very important. We have already discussed guys a number of things in CPC. So, in this order, I mean this order is different from other orders, like you have read about section 9 suit of civil nature, or about jurisdiction also you have read. Apart from it, you have read res judicata section 11 of CPC, and place of suing also I have discussed in the same class. So, this one is fifth one, suit by indigent person. I mean to say, without understanding this one, because in our India we have around 40 to 50% people who are below poverty line. If they are not able, because this order actually makes or enables you to file suit, because you know without money you cannot engage lawyer, without money you cannot pay court fees also, or apart from it other expenses. So, basically this order will give you sort of space, like especially this order is meant for those people who cannot afford the court fees, who cannot afford the fees of advocates, who cannot afford the fees TA and DA, especially for what is awarded or what is prescribed for witnesses and other litigation expenses. So, if you understand this order 33 CPC, you will come to know, because in order 33 we have a definition or as well as meaning of indigent person. Indigent person means who is poor. So, with this, because we have in our Indian constitution also we have a number of provisions, especially in directive principles of state policy, like state will provide free legal aid to poor people or those who cannot afford this much, I mean litigation expenses. So, no one should be deprived of litigation, no one should be deprived of legal aid, not litigation, legal aid. There should be, I mean justice for all. So, this order will give you this understanding, like if you are not in a position, then with the help of this order or with the permission of the court, if you file application under order 33 of CPC with the help of this and get permission from the court, then you can easily file your suit. Although this exemption is temporary for the time being, but still I will say that this is very helpful, and this is helpful for everybody, those who cannot afford. So, here on first slide you can see even the purpose of this order 33 also, to protect bona fide claims of an indigent person. So, basically this word is very important, indigent person. I will let you know what is indigent person. So, as per rule first of 33 CPC. Second one is to safeguard interest of revenues, regulation of court fees, to protect defendant from harassment. If this right was not existed, then the rich people on behalf of the poor people could harass the defendant, or could harass the rich people, could harass the poor people. So, this purpose is very important, although I have already cleared this one, but still you should understand with the help of this slide also, it means basically this is a kind of safeguard from harassment. So, this is rule first of order 33 of CPC. Here, in order to get relief under order 33 of CPC, the parties plaintiff and defendant, basically they can claim or they can file application under order 33 of CPC, and the rule first, because without understanding rule and the language of rule, I think this will be really difficult for the student, those who are new in this CPC. So, that is the reason I am going, or I will clear this topic with the help of rules. And apart from this one also, I will give you one case law also, Union Bank of India and Khadar International Construction Limited Company. I will tell you ki how this rule particularly covers artificial persons also. But first read this language carefully and try to understand this order 33 or the concept of indigency or the concept of indigent one with the help of this rule or with the help of these rules. So, suit may be instituted by an indigent person subject to the following provision. A suit may be instituted by indigent person. So, who is an indigent person? If he is not possessed of sufficient means, this rule 1 is very important. If somebody is not possessing sufficient means, if sufficient means, because there is no clear definition of this word sufficient means also, because this varies person to person also. Some people includes even the ordinary items or the basic things if you have, or some people includes even the luxurious items also, those I mean who do not understand, because if that has become a part of their life, then they include sometime even apart from basic things, they include even some sort of luxurious items also, okay, this is also basic part of our life or basic necessity of our life. But sufficient means ki, like sufficient, in order to understand this sufficient means, this word, these two property you have to exclude. This application order 33 application, guys, you have to file along with your suit, whatever you file before the civil court. So, this application is apart from order 33 application is apart from your suit. Court can permit you or court cannot permit you, court can reject or court can accept your application. If court accept, then you will get or litigation expenses, you will get lawyer also. Rule 8 of CPC of the rule 8 of this order 33 specifically talks about it, ki what kind of exemption you will get. If the court does not grant it, then you can file your suit or you can contest your suit in an ordinary manner after paying court fees, I mean to say. And this court fees is not something like 100, 200, it varies case to case also. There is a court fees act we have, because civil cases, I already told you when I was discussing section 9 of CPC, civil cases are basically paid services. And what I feel and what I have seen, like what our student understand, like they think this court, if you the moment you file or once you file your suit, then this becomes the state responsibility, this becomes the state responsibility, because providing justice is the state responsibility, no doubt. But so far as criminal, there is a big difference here also with this help of, I mean in this provision also you can understand the difference between civil and criminal matter. In criminal matter, the moment you lodge FIR, the case becomes state case and state will provide, because police will investigate and all those things, state will provide you public prosecutor. So, it means state will bear all expenses on behalf of the complainant, on behalf of the person who lodged the FIR. But civil matter, this is the word civil itself defines in section 9 also, private rights and remedies. So, the matter is in our layman sense, I will say, not in lawman sense, I will say ki this is the matter between, try to understand this word, the matter is the private matter, the civil matter is between you and me. I am not using law language, I am saying ki this is in layman sense. You will understand the matter is between you and me, then why the state bear all expenses, why the state bear all this cost? If you enter into an agreement under civil contract act or sale of goods act, partnership act or any other kind of civil contract, then the matter is between you and me. You will and me, the party will bear the, you know, they will share the profit, they will share the losses also. So, they will bear the cost of fee also, the cost of all litigation, and litigation, cost of litigation includes the cost of court fees also, stamp duty as well as other litigation expenses. You have to bear, we have to bear, the party has to bear the expenses. State has no role, state will not come into picture. Just providing this is service, we have no doubt that we have civil courts, we can apply or we can bring our matters before the civil court, that is a different thing. Court will provide justice to us, but so far as cost, so far as expenses are concerned, expenses in the form of, you know, money, like what you pay in the form of court fees. I already told you that this cannot be 100 or 200 rupees, this varies case to case. In some of the matter, like if you are claiming 5 lakh rupees as a compensation, or if there is a recovery of money matter and you are claiming lakhs of rupees from the opposite party, then you will pay as per the Court Fees Act, 10,000, 20,000, I mean, for that you have to see the Court Fees Act. So, this shows even before the consumer protection, consumer courts also, consumer firms also, you have to pay the court fees in the form of challan or in the form of, you know, I mean, sometimes you get deposit in the treasurer also, or sometimes you get you deposit in the form of challan also, or you purchase stamp paper of that much amount, whatever the amount is there in the Court Fees Act, and you engage lawyers also, and apart from it, whatever the cost or whatever the fine or whatever the you know, TADA travelling allowance, especially for witnesses, or dearness allowance, whatever subsistence allowance, whatever in order to appoint commission, whatever the fees is prescribed or whatever the fees is decided by the court, you pay from your own pocket. This is what I want to emphasize. The party, the concerned parties pay from their own pocket. If you have money, then you can contest your matter, otherwise no relief. But if you are, so that is the reason we have, I mean, legislature has designed this provision, order 33 of CPC, like there should be, there are number of people who are below poverty line, who cannot afford heavy cost or heavy court fees, who cannot purchase stamp paper, or number of other who cannot bear litigation expenses. So, just to provide relief to them, this provision has been defined, suit by indigent person. Indigent means who is a poor one, who is not having sufficient means, who is not having even 1000 rupees if the fee is not prescribed, second B part of this rule 1, you will come to know this one. So, you have to pay, again I will emphasize, you have to pay from your own pocket. So, that is the reason the importance of this order 33 CPC becomes more relevant. So, this thing always we have to keep it in mind, that this civil services or the services, the judicial services, whatever we are getting from our civil courts, we have to pay for that. We cannot get relief from the court. If you are in a position to pay, then we cannot get this relief without or free of cost. So, that is the reason the word this indigent person becomes relevant here. If you understand this rule 1, I am taking much time on this rule 1, because if you understand this rule 1, then I hope you will understand the entire order of this 33 of CPC, because this is important, this rule 1 is important. Some people or some students are confused with this word, who is indigent one, what does it mean, the means of sufficient means, and apart from it, other than property exempt from attachment in execution of a decree and the subject matter of the suit. This court will not take into account in order to decide the question whether you have sufficient means or not. If he is not possessed of sufficient means other than property exempt from attachment in execution of a decree and the subject matter of the suit. Subject matter, whatever, if you are claiming 10 lakh rupees, or if there is a matter of recovery of money for 10 lakh rupees or suit for immovable property. So, that will not be taken into account, or that will not decide the question of your indigency, the property, because otherwise you can say, so okay, no, he is claiming this much immovable property and worth this much worth of this much rupees, then that will not be taken account, that will not be taken into account in order to decide the question of indigency. That is a suit subject matter. Let the court decide, and lastly when you get a decree, then you will come to know whether the property is of yours or not. In the beginning, how can you say that? You are just claiming, you are filing your suit. Whether you will get decree in your favor or not, that is a different thing. So, right now you cannot, or in the beginning you cannot say this thing, this I mean this subject matter decides ki you are rich one, subject matter of your suit decides you are rich one, that is not deciding. So, that is the reason we are excluding this property, subject matter, whatever the subject matter of your suit is there. Apart from it, other than property exempt from attachment in execution. Execution, you understand section 60 of your execution, the property which can be attached and which cannot be attached. Keep it in mind, and if you want to write, then you can write also. Section 60 of your execution, section 60 of your CPC, section 60 order 21, section 60 order 21 decides, basically defines the property which can be attached or which cannot be attached in execution. Execution means to realize the fruits of your decree. Understand this one, execution. What is execution? If you do not understand, then you will say ki no, what kind of property exempted from attachment. Execution means to realize the fruits of decree. After getting decree in your favor, you becomes the decree holder, and the opposite party against whom the court passes the decree called judgment debtor. Then against the judgment debtor, again after getting decree, you file application under order 21 of CPC, that is called execution. And we have under section 51 of CPC, 51 of CPC, we have 5 mode of execution: specific delivery of property, attachment, without sale, and sale with attachment, apart from it arrest and detention, appointment of receiver, or any other mode. These are 5 mode. So, you will come to know section 60 of CPC is talking about the property which can be attached or which cannot be attached. So, which cannot be attached will come here in this clause A of rule 1. Exempted property, exempt from attachment in execution, like your wearing apparels. It means the basic items, what you need, what is the basic items, your all vessels, tools, your house in which you basically you reside, your wearing apparels, and apart from it your bedding and agriculturalist tool. These are all property which are exempted. This, it means exempted from attachment means this property cannot be attached by the court. If you have this much property, so this will also be taken into account. Court will not calculate, because court is deciding here in order 33 whether you are an indigent person or not, whether you are a poor person or not, because you need relief from the court fees, exemption from the court fees. So, that is the reason this question you are, I mean the court is deciding on the basis of your application, what you have filed along with your suit. Otherwise, ordinary suit, if the court does not grant you permission. So, exempted property. So, these, there is a complete list in section 60 of CPC itself, you can go through, both the properties are there, property which can be attached and which cannot be attached in execution. So, court will not attach property, the property what has been there in the list of exempted property. So, these two properties, subject matter of the suit as well as exempted property, court will not take account. Then court will decide whether you have a sufficient means or not. If the fees is prescribed, see this one also, this is also very interesting. If the fee has been there in the Court Fees Act, then court will take into account this mean, sufficient means. If the fees, a specific amount 10,000, 20,000, 5,000, whatever the amount is there as per your court subject matter. Then court will decide after exempting this much, these two property, exempted property as well as subject matter of the suit, court will decide whether you have sufficient means or not. So, again there is a no clear cut definition of this word sufficient means, varies case to case. If you have these two property, exempted property, this cannot be attached in any way, subject matter will not be taken into account, then court will decide if prescribed fees is there, whether you have sufficient means or not. If you do not have sufficient means, then court will grant you permission, okay, you are an indigent one and you can continue with your suit, this civil suit. Second one, where no such fees is prescribed worth 1,000 rupees, where no fees is prescribed 1,000 rupees. See this one, very interesting, only 1,000 rupees. If there is no fees in the Court Fees Act, then 1,000 rupees will be taken into account, whether you have 1,000 rupee or not. That will decide the question or the status of indigency, whether you are indigent one or not, whether you are poor or not. If you do not have even 1,000 rupees in this particular case, where this fee is not prescribed, then court can grant you or court will grant you the status of indigency after taking into account if you do not have 1,000 rupees. So, these two things, clause A and clause B of rule 1 order 33 of CPC, specifically talking about ki whether a person is an indigent person or not. I hope you got this point. There is a explanation also, explanation, very important explanation. Any property which is acquired by a person after the presentation, mark from here, after the presentation of his application for permission to sue as an indigent person and before the decision, from here to here you have to mark. These two lines are important. After the presentation of his application for permission to sue as a, it means after filing or after presentation of your application and before the decision of your case, if you get any property, that will be taken into account in considering the question whether or not the applicant is an indigent person. Before, after and before, these two words you have to understand, after and before, after and before. After the presentation of the application under order 33 of CPC and before deciding or before deciding the question of this application, before deciding the case, after the presentation of the application under order 33 and before deciding the case, if you get within that much time, this can be 1 year, 2 year after the presentation and last point decree, getting decree, see this one. So, during that period, it means during the trial, if you get any kind of property, then court will take into account whether you are an indigent one or not. Does not mean that like if you get permission in the beginning and subsequently if you get property, suppose after filing of your suit after 6 months or 4 months, if you get any property, then court will not take into account. Court will take into account, because court is not, this is paid service. Again I am reminding this one, civil services or the relief in civil matters, this is paid service. This is temporary exemption, no doubt, good relief under order 33 of CPC, at least temporary relief, but at least you will get justice. Subsequently, in rule 10 and 11 you have in the same order 33 of CPC, if you succeed then you will pay, if you do not succeed then also you will pay. There is a provision for that, these provision rule 10 and rule 11. But this much relief, temporary exemption is important, this much relief is a big one relief. Explanation third, where the plaintiff sues in a representative capacity, the question whether he is an indigent person shall be determined with reference to the means possessed by him in such capacity. Representative capacity, this is also important word, representative suit and representative capacity. If you are representing someone, then with that in such capacity whatever property you are having, that will be counted. In that capacity, if you are in a representative capacity, suppose you represent someone, then that will be, it does not mean that like if you say no, let's, because I am rich one, so I should not file, or instead of filing personal or on and on filing, let me engage someone who will file on my behalf, that will not save you. If you have in that capacity, if you have money, then court will take into account that one also. So, rule 1 of order 33 CPC talking about specially whether you are an indigent one or not. So, these two things, sufficient means if there is a prescribed fee in the Court Fees Act, and if no prescribed fees, then worth 1000 rupees will be taken into account and will decide the question of indigency, and court will exclude exempted property. For that you can read section 60 of CPC and subject matter of the suit. Court will not take into account these two things. Then by excluding this one, court will decide the question of indigency. Apart from it, this explanation says ki if after filing of your suit and before deciding the case, if you get in the meantime or during the trial, if you get any property, then also court will take into account whether you are an indigent one or not. This is the question of, will decide whether you are an indigent one or not. Now, see rule 1A, inquiry into the means of an indigent person. Chief ministerial officer of the court, every inquiry, like you cannot take it lightly, okay, once court decides just on the basis of your whether you have sufficient means or not, by taking or by accepting your presentation, or by just going through your plaint or your application, or on the first date of hearing, if the court accept your submission, okay, you do not have sufficient means, you do not have property of worth 1000 rupees, or you, these two things specially. This court will conduct inquiry relating to this one, and this inquiry will be conducted by the chief ministerial officer of the court. Unless the court otherwise directs, the court may adopt the report of such officer as its own finding. Chief ministerial officer court will decide, will go through your application, can conduct inquiry also, whether really or you are telling lie or you are really a honest one, whether you have that property, whatever you have stated before the court of law or not. Sufficient means just by taking your words or accepting your words on the first date of hearing is not enough. If you say no, your lordship, I do not have sufficient means, if you say no, I do not have even worth 1000 rupees, so kindly give me permission or kindly accept this application of indigency, so that is not enough. For this there is a need of inquiry, and court can, if the court think fit, the inquiry will be conducted by the chief ministerial officer of the court, and this officer will be appointed by the court. Inquiry means inquiry, he can search your place of residence also, visit your place of residence also, not search, visit your place of residence also. Apart from it also, he can come to know, or he can ask about your accounts, and he can ask about, he can collect all other kind of evidences also relating to this one, whether really you have sufficient means or not. So, this is also very important. So, you cannot lie everything before the court. What are the content of application? With this also you can understand this one, like how the inquiry will be conducted by the court. Every application ki schedule of any movable or immovable property belonging to the applicant with the estimated value thereof shall be annexed there too. Every application for permission to sue as an indigent person shall contain in your application itself whatever you file, what you file under order 33 of CPC, in order to get the status of indigency, because you need exemption from the court fees or the litigation expenses, then along with your application you submit this schedule of your movable and immovable property also, and this is mandatory. You cannot avoid this one, whatever property you have, movable property or immovable property, and that can be verified by the executive authority, like Patwari is also there, Kanungo is also there, Tehsildar, Naib Tehsildar is also there. if you have any immovable property. So, that is no doubt in urban areas the properties are registered one. Even in rural areas you have registry, you have other documents relating to your property. So, this can be easily verified. Or apart from it also the Patwari Kanun ko Tehsildar, Naib Tehsildar, SDM, these executive authorities are there. This is the work of these authorities. So, court can direct these authorities, go and ask about this one, or this chief ministerial officer whosoever is appointed in rule 1A of CPC, this order 33 of CPC. They can take the assistance of this executive authority, ki really whatever you are saying or whatever the schedule of your property you have attached with the application, whether this is right one or not one. So, you cannot lie before, you cannot conceal anything, or I will say, I will suggest you you should not conceal anything from the court of law, if you are trying to get relief under this order 33 of CPC. So, we have this judgment also. So, you can go through this one. So, schedule of movable and immovable property, and it shall be signed and verified in the manner prescribed for the signing and verification of pleading. Signing and verification, you know this thing, how we verify plaint, how we sign plaint, all those things, the things are there in will be applicable here in this case of order 33 also. Presentation of application, rule 33. Presentation of application, the application shall be presented to the court by the applicant in person. If you are, so this you should prefer this one, and court will also prefer this one, if the application must be presented in person, unless is exempted from appearing in court, in which case the application may be presented by an authorized agent. So, if court directs, this is absolutely in the hand of the court. If the court say no, you should present it in person, then court can make it mandatory also. Otherwise, your agent also on your behalf, he can also appear before the court of law, and he can present the application. Okay, this is the application under order 33 of CPC. So, depends on the court and how the court accept it, whether court accept it or not. That's the question here. Presentation of application. Who will present application of order 33 of CPC? Examination of applicant. This is also, there are two examination. One is under rule 4 of CPC in this 33 order 33 itself. Another one is rule 7. So, there is a difference between rule 4 and rule 7 of 33 order 33 of CPC itself. What kind of examination takes place, how the court would examine. So, see this one, the rule 1, this part 1 of this rule 4, where the application is in proper form and duly presented, the court may, if you think fit, examine the applicant or his agent when the applicant is allowed to appear by agent regarding the merit of the claim and the property of the applicant. Court can ask on the first date of hearing itself, when you are appearing in person or your agent is appearing in person, if the court accept. Otherwise, if the court does not accept, then the court can appoint even commission also. But order 26 of CPC, appointment of commission, he will record the statement. But if the court accept and you are appearing in person, then court on the first date of hearing, this becomes the duty, and court would ask the applicant, okay, what is your name, what is your claim, what you are claiming, how you are saying you are an indigent one, whether you have sufficient means of property or not, what property you have. This small question, just to verify whether really you are a genuine applicant or not, whether really you are a honest applicant or not. So, this kind of examination, this is called examination on the first date of hearing. If there is no substantive case is made out, if your answer is not satisfactory, if the court is coming to know, no, you are telling lie something, you are concealing something from the court, then court will reject it directly, this application of order 33 of CPC. So, you cannot conceal. Examination is very critical one, because you are getting relief, you are getting exemption from the litigation expenses, and I hope I have seen this court takes it very seriously, civil courts takes it very seriously, because otherwise if the court grants, otherwise there are a number of people in civil matters and coming and trying to claim the status of this indigency. If the court takes it lightly, then number of people, and this will again will be a burden on the court, increase of cases there will be again, because if you accept this kind of application easily without any examination, if the court accept, if the court accept this kind of application without any examination of applicant, then court more and more people will come. So, that is the reason here in this case order 33 of CPC, when court is deciding the status, whether really you are a poor one or not, whether really you are an indigent one or not. So, courts can ask number of questions relating to your property, movable property, immovable property, the source of income, what you are earning, what's your, I mean, how family members are there, how you are, I mean, feeding them, and all those questions relating to your property can be asked by this. This is called examination. If presented by agent, to second part, second one, the court may order applicant to be examined by commission also. If presented by agent, then court can appoint commission. Then commission means local commissioner. Order 26 of CPC, local commissioner, LC, normally we call in our law language LC, local commissioner. He can also be officer of the court, he can be a young lawyer also, those who are serious one in practice, or he can be officer of the court also. He will visit the place if you are not appearing or if you are not in a position to come before the court of law, then he'll go there and record the statement of that applicant, okay, what kind of property you have and all these things, examination related questions, and will submit the report before the court of law. So, this is about examination of application. So, this is not easy one if you think, and rule 5 talks about rejection of application. On what ground court can reject your application? The court shall reject an application for permission to sue as an indigent person where it is not framed. This rule is very important, rule 5 is very important. Where it is not framed and presented in the manner prescribed by rule 2 and 3, not presented and framed and presented, it means where if you do not submit schedule of movable and immovable property, if you do not frame it as per order, rule 2 and 3 of this CPC, this order 33 of CPC, then court can reject your application. So, you have to be very cautious when you draft this application under order 33 of CPC, because you are getting exemption from the court, you are getting exemption from the litigation expenses, and this can be a heavy amount of expenses, heavy amount of money, I mean to say. Second one, where the applicant is not an indigent person, same thing. If you are not an indigent person, then definitely court will reject it. No need of more understanding, because you already understood this one, who is an indigent one, how the court grants the status of indigency. C, where he has within 2 months next before the presentation, this word is also very important, 2 months, 2 months, 2 months. If you dispose in order to get the status of indigency under order 33 of CPC, if before the presentation of the application, if you dispose of property within 2 months, then court will take account, it means you have a mala fide intention. Wrongly and mala fidely you disposed of your property because you want to get the benefit of this order 33 of CPC just before 2 months. And I have seen personally in cases like number of clever clients, they adopt this I mean they do this kind of things also. They dispose of their property and they say, no, we are an indigent one, we do not have this much money, grant the permission of this status of this indigency. So, within 2 months next before the presentation of the application, disposed of any property fraudulently or in order to be able to apply for permission to sue as an indigent person. So, this is very important before 2 months. So, for that also you need investigation, you need inquiry. So, that is the reason in earlier rules there is a provision that chief ministerial officer of the court will make this kind of inquiry whether really you are an indigent one or not. You can conceal, but your witnesses, your statement or your neighbors or your surrounding circumstances, if the chief ministerial officer visits your premises, your residence, then he can ask from the neighbors also, he can ask from other peoples also, he can ask take assistance from the executive authority also, like whether he has sold out some property or not, whether he had some property or not. So, this kind of question can be asked, and within how much time this property has been sold out, all these things can show your really whether really you are showing something or you are concealing something. So, if you do, so I will suggest you do not do this kind of thing. There is this time limit also for this one within 2 months. If you have done long back, then that is immaterial, But right now if you have done within just within 2 months, then that will be taken into account ki no, you are not an indigent one, and court will straightforwardly reject your application of this order 33 of CPC. Provided that no application shall be rejected if even after the value of the property disposed of by applicant is taken into account, the applicant would be entitled to sue as an indigent person. This is very easy, like if whatever you have sold, even if we take into account that the value of that property, and after that if we comes to know, or if the court comes to know, no, still you are an indigent one, then this is the question, then court will not reject your application. D, where his allegation do not show cause of action. This word cause of action is very important. First understand this one, and then I let you know what is where his allegation do not show a cause of action. Cause of action means bundle of essential fact. It means your subject matter, your civil suit along with your application. If your civil suit is not showing a cause of action, although you are claiming the status of indigency, that is a different thing, you are filing along with your plaint this application also of application under order 33 of CPC. If your court, if your suit is not your allegation, whatever you have problem or your grievance is there, if that is not showing a cause of action, then court will reject your application. And this we have in order 7 rule 11 of CPC also. For this you can read this one also, rule 11 of CPC also. If the cause of action is not there, then court will reject your plaint also. So same thing is there, if your allegation do not show a cause of action, whether really you have a legal cause of action or not, against whom you are claiming, your case is just baseless, no case is made out, then what kind of status you need, what kind of exemption you need. Court will reject your application if you want to continue it with your as an ordinary suit. So that is a different thing, whether you get in your favor or not, or whether you will be able to prove or not. Because filing case, see this one, whatever I am saying, there is a meaning of this one, this statement. Whatever filing suit and getting relief or proving your case, both are two different things. Filing civil suit and proving the case, both are two different things. If you file case and you think no, you have, you will be able to prove this case also. So that is not the case. For that you need evidence, documentary evidence, primary evidence, secondary evidence, you need for that. So if your allegation do not show a cause of action, then also court will reject your application. E, where he has entered into an agreement with reference to the subject matter of the proposed suit under which any other person has obtained an interest. If there is this is also very important, this kind of things takes place really in practical life, you will see all these things. Suppose you enter into an agreement and somebody has interest in your subject matter, and you are entering into an agreement with that person. Okay, if he is saying okay, I will finance you, I will give you money, you go with this civil suit, and because you are poor one, you can easily get the status of indigency also. Although I have interest, I have money, I am not filing directly, I am just provoking you, you instead of filing directly, if I am provoking you, you should file on and on. I have subject matter interest, but just on my behalf, if I am not directly in picture, I am just, there is an agreement between you and me, between the poor one and the real party. If this kind of agreement is there, then this kind of things also, court can reject your application. Normally in class also I give these examples, like in different government Awas Yojana, free house for the people who are below poverty line. Normally what I have seen, property dealers, the moment this kind of schemes comes in picture, okay, there is a 100 Awas or 100 premises, 100 free houses for those who are below poverty line. So property dealers, they collect, because this is available only for those who are below poverty line. So property dealer basically they visit that area and try to collect the information who is below the poverty line in this area, who can apply for this plot or for this residence, who is offered by the, which is offered by the state government or central government, different Awas Yojanas. So for that they will bear all expenses, and they enter into agreement with the poor people, if you get this awas or this residence, then I will sell it out, resale will take place and I will give you this much money for this one. And they apply even for, they collect, suppose they collect information from 100 people, or they file 100 applications on behalf of 100 people, they are filing directly, they are in picture, the poor people are in picture, they are just behind the poor people, they are financing, because the poor people, they do not know whether there is a scheme, government scheme or not, state government scheme or central government scheme or not, they do not know how to resell it, they do not know in how much amount they have to sell it out, everything will be done by the property dealers or those, this kind of mafia, those who are doing this kind of jobs, and poor people will be in picture. So, subsequently if out of 100 applications they get, suppose 5 people, poor people, they get residence in their own name, then agreement is there between the rich, between the property dealer and the poor people, those who are below poverty line. So, then subsequently the things will take place, whatever has been offered earlier or whatever has been promised earlier, they will pay this amount and they'll resale will take place, or some other things will kind of transaction will take place. This kind of agreement I am talking. I am just giving example. Apart from this also there are number of things, number of agreement can be there between the those who have subject matter interest. And in G also, G part of this rule itself, where any other person has entered into an agreement with him to finance the litigation, there are people who can finance the litigation also. So, this kind of now you have to imagine what kind of finance can take place, because this application or this relief under order 33 of CPC is only for the indigent people, only for the poor people, because our constitution of India is especially talking, directive principle of state policies are laying down this one, no, there should be free legal aid, there should be justice for everyone. Constitution of India is saying justice should be for everyone. So, that is the reason legislature or government has legislated or kept this provision in CPC. So, this kind of things. F, where the allegation made by the applicant in the application showed that the suit would be barred by any law for the time being in force. If there is any other kind of bar like limitation bar or minor kind, because minor cannot enter into an agreement, or there cannot be an agreement with minor. So, if there is this kind of bar or limitation kind of bar is there, Limitation Act 1963 kind of bar is there, then also court can reject your application. So, this is very serious application and court will take it very seriously, court will examine it properly. After examination in person and under going through this rule 5 of CPC, you can come to know if there is no cause of action, if there is a disposal of property within 2 months, or if there is any other kind of bar, or if there is a finance kind of thing, so if somebody is financing, then court can reject your application. Notice of day, rule 6, notice of day for receiving evidence of the applicant indigency. This is very simple one, for this, if you are filing this application, then at least 10 days notice will be given to the opposite party and the government pleader. See this one, opposite party and the government pleader. Government pleader who is, because government pleader is specially working for the state government, opposite party will also bring this thing in the knowledge of the court. No, your lordship, this person who is claiming the status of indigency is not an indigent one. Just by filing application, if you say no, I do not have sufficient means, I do not have money, you cannot get this status of indigency. Opposite party can also bring this thing in the knowledge of the court. Government pleader also can bring in the knowledge of the court, no, your lordship, this person is not an indigent one. So, this is very serious thing. 10 days notice would be given to these two parties, opposite party and government pleader. Then court will decide finally whether you are an indigent one or not. There is a rule 7 also, examination, procedure at hearing. See this one, shall examine the witness if any produced by either party, and may examine the applicant or the agent, shall make a full record of the evidence, shall examine the witness on the days of fixed or as soon as thereafter as may be convenient, the court shall examine the witness. Whatever witnesses to whom you are bringing, or to whom you are saying no, these are my witnesses, court will also examine those witnesses, how you are saying this person is an indigent one. On what basis you are saying this person is an indigent one? In rule 4 you have read, court will examine the applicant in person or agent, or if there is agent, court accept the agent, then commission can also be appointed. But here in rule 7 court will examine the witnesses to whom you are producing or to whom you are saying ki, no, these are my witnesses, you can ask this thing ki whether really I am an indigent one or not, because this is your case. Burden of proof you have read, Evidence Act 101 to 106 of CP, Evidence Act you have read, upon whom the burden of proof will lie. In civil matter, section 101 and 102 of Evidence Act specially saying the burden of proof is on the party who is asserting something before the court of law. Ki this is my case, then burden of proof will also lie on that party. So, that is the reason first burden is on the applicant, then second burden is on the witnesses to whom you are producing before the court, ki whether really the applicant is an indigent person or not. So, this is how the court will examine same kind of questions, otherwise you can also be prosecuted, you cannot tell lie being a witness. Chief examination, cross examination, opposite party can also cross examine you if it is permitted by the court. Re-examine also, you can also be re-examined by the court if there is a permission. So, you cannot take it lightly, like whatever you are saying that is the last word and the court will say no, okay, really you are an indigent one, court will grant you easily, because this is a exemption from court fees, litigation expenses. In rule 8 you will come to know what kind of expenses, although in beginning I told you what kind of expenses come within the picture of this, this exemption. But here in rule 8 you will find it finally, plaintiff shall not be liable to pay if this permission is granted to you. Plaintiff shall not be liable to pay any court fees or fee payable for service of process. It means someone for some months also. Suppose there are 5 defendants, then you have to pay as whatever is asked by the court, ki okay, 100 rupees postal charges, 100 into 5, 500 rupees postal charges. This is called service of process. Court fees, whatever is there in the Court Fees Act. Process fee even for witnesses also, to whom you want to call. You have to, because that is the reason I was telling you, this is paid service. For civil matter, this is paid service. If you do not have money, then you cannot contest, or you can contest in an ordinary manner by paying fees. But you have to understand what kind of exemption. So, that is the reason order 33 is very critical and important one. You will get a full exemption if court accept this application. First, plaintiff shall not be liable to pay any court fees or service of process or in respect of any petition, appointment of pleader, other proceeding connected with the suit, appointment of pleader. You know this thing, appointment of pleader, how much fee or advocates demands especially. So, that is the reason we are called sometimes ki this is a very costly affair, this is a costly litigation, is very costly one, dilatory process, costly one, advocates are charging very high amount of fee. In civil cases, I mean in civil, this one before civil courts, advocates in district courts, they can be charged, they can charge nominal one, but so far as honorable high courts and Supreme Court is concerned, you can't imagine even the lawyers what they are charging for these cases in lakhs of rupees. So, if you get this liberty or if you get this exemption at the district level or by the district court itself, then this will be a great relief for you. You will get exemption from the court fees, whatever the court fees, 10,000, 20,000, whatever the court fees amount is there, as per your, this varies matter to matter. You have to find out, or for this you should refer this Court Fees Act. Process fees, appointment of pleader or any other proceeding connected with the suit, other proceedings, whatever the proceedings, like for appointment of local commissioner also you need, you have to pay the amount, because court, appointment of receiver, appointment of local commissioner, calling witnesses, subsistence allowance. So, there are number of expenses throughout the trial, throughout the proceeding, and you will get exemption from all those expenses if your application is accepted by the court. Withdrawal of permission. So, rule 9, If you are indigent one, vexatious claims, improper conduct or agreement kind of things, the same whatever you have read in section rule 5 of CPC. So, then court will can withdraw also permission to sue as an indigent person, if the once if suppose court grants permission in in innocence or without coming to know this thing. If the thing is not coming before the court, then if court comes to know, then court can withdraw this permission also. Rule 9 and this one rule 10 and 11 is also I want to emphasize this one. Cost where indigent person succeeds, if you succeed suppose, then such amount shall be recoverable by the state government from any party ordered by the decree to pay the same, and shall be a first charge on the subject matter of the suit. So, if you get permission does not mean that the permission is permanent one, the exemption is permanent one. If you get the status of indigency and get permission to contest this suit, then that does not mean that this exemption from court fees is permanent. Under rule 10 of CPC, this 33 itself saying, if the state government, this would be a first charge on the subject matter, and court will shall be recoverable by the state government. State government will recover through the district collector, deputy commissioner. He will initiate the proceeding ki how to collect this cost from you or out of your property or out of your subject matter. If you succeed, then definitely court will deduct it, no problem, because the thing is in the hand of the court. But if you fail rule 11, then also court will see this one. If the plaintiff does not this because the summon for the defendant to appear and answer has not been served upon him in consequence of failure of the plaintiff to pay the court fees or postal charges for such service, or to present copy of the plaint or consigned statement, because the plaintiff does not appear when the suit is called on for hearing, the court shall order the plaintiff or any person added as a to pay the court fees which would have been paid by the plaintiff if he had not been permitted to sue as an indigent person. It means even then you have to pay if you if you fail. This is rule 11, indigent in case of when suit abates, state government may apply for payment of court fees. Rule 12. So, state government, this is also very important, ki shall have the right at any time to apply to the court to make an order for the payment of court fees. State government has also, because otherwise you are getting exemption. So, this is a loss directly to state government. So, state government can also apply to the for the payment of this court fees. See rule 14, forward it to the collector who may with prejudice to any other mode of recovery recover the amount of court fees specified. So, through district collector court can recover this amount of money. So, there are 18 rules. So, these were important rules what I have discussed here. So, apart from it, there we have Union of India, one judgment, Union of India versus Khadar International Industries, Khadar International Industries, 2001 judgment. So, you can go through this judgment also. In this judgment, specifically this has been held by the court that this order 33 covers not only natural person, but it also covers juristic person also. Juristic person means body of individuals, association or company. It means all artificial person also can get this status of indigency. Natural person no doubt they can get, but even unnatural or artificial person, juristic person like company, public limited company or any association, they can also get the status of indigency. This is very new thing and you will be surprised to know this thing, even they can also get the status of this indigency, and how they can get under order 33 of CPC they can get relief. So, this is all about order 33 which talks about especially what I have discussed. So, this is all about like who is an indigent one and what decides the status of indigency. Thank you.